If you own all or part of a business in North Carolina and you have a child with a disability, your operating agreement is probably writing your estate plan for you, and it's writing it wrong. In the next few minutes, I'm going to walk you through the 3 areas where business owner estate plans break when you have a child with special needs involved, what to fix in your operating agreement, and how to keep a buy-sell agreement from disqualifying your child from the benefits that they need. Most operating agreements were drafted before the child was born or diagnosed. The buy-sell triggers on your death, and the proceeds of that pay to your estate. The estate gets distributed under your will or under intestacy. Your child with a disability gets their share outright. And the SSI eligibility that you are working hard to preserve evaporates over the next week. The typical buy-sell agreement in an operating agreement requires your other partners, the other co-owners of the business, to buy out your share at your death and pay the proceeds to your estate, coordinating with your personal representative or executor, whether you have a will or not. The unfortunate outcome to this is that all roads from your estate probably lead toward an unintended outcome. Your child with the disability receiving an outright interest in the sale proceeds from your business. And it doesn't matter if this is funded with life insurance or not. All roads lead to the unintended circumstance. We can use trust planning to de-weaponize the standard buy-sell agreement language in an operating agreement. We can hold your interest as a transfer on death membership interest so that it transfers upon your death to your trust. And all sales and coordination go to your trust instead of to your estate. If we created the trust ahead of time, then it means the benefit passing to a child is going to be very intentional instead of inadvertent. If you own part of a business in North Carolina and your estate plan is 5 years or older, the link below is the best place to start. But it's not enough just to change that transfer on death provision. We need to coordinate it back to the trust so that the buy-sell is actually coordinating with the trustee of that trust rather than still going through your estate. It's one thing to change the outcome. We still want to simplify the process too. Most buy-sell agreements inside an LLC operating agreement don't contemplate estate planning at all. It's just default to the estate one way or another. And we want to make sure that once that purchase and proceeds transfer to the revocable trust itself, that there's some intentionality around what's going to a child with special needs versus the other family members, the spouse, any other children, charities, or any intended beneficiaries that you may have. There should be intentionality in funding, not just to throw our hands up and hope it works. But that being said, no business owner estate plan that contemplates leaving a benefit to a child with a disability is ever going to be perfect. There's always moving targets in terms of values and asset classes along the way. And we can create a lot of analysis paralysis trying to focus on the perfect outcome. What we do want, though, is intentional and solid and done, not perfect and undone. Business owner estate planning is one of those areas where the cost of getting it wrong shows up at the worst possible time, when your family is already grieving and your partners are already nervous. If you're a business owner in North Carolina and you have a child with special needs and your estate plan hasn't been reviewed alongside your operating agreement, the consult link below is the next step. Send this to your business partners too. Protecting your family requires more than just standard documents. Schedule your consultation with our team today.